Okay, a very warm good morning to one and all. Actually now it's good afternoon. Very warm good afternoon to one and all. So today here I will be talking to you about the next 45 minutes on patent prosecution system in India from filing to grant. So you know now in India it's a now technology driven society, right? So securing a patent has become very much crucial nowadays, actually crucial than ever before. So you must have a very clear idea how to patent your idea, I mean how to patent your invention. And also I will be talking to you about how after drafting and filing your application, how it is taken at the patent office till the grant or sometimes rejection. So what is the process which is happening at the patent office? Okay. So patent prosecution, as the term indicates, it is nothing but interaction. It's a process of interaction with the patent office in order to secure patent for your invention. So this may be, you might be now very familiar with what are patents, and it's a type of intellectual property. So I won't be explaining much about other intellectual properties, and it may seem repetitive to you, but still it is very important. I will take you to once again the concepts of inventive step, novelty, industrial applicability, and the patentability subject matter. As ma'am and all the speakers before me have told about the patents. So patents are given for inventions for a product or a process, and they are territorial, of course. Territorial means, as everyone has explained, when you apply a patent in India, you get protection only in India. Okay, and it is for 20 years. It's limited. Its time period is limited, and they are nothing but exclusive rights. You get to exclude others from replicating your invention. Okay, you get rights over it. Rights in the sense to exclude others from making, using, selling, importing for sale. All those things, you get a right for a particular period of time. And of course, as everyone has mentioned, your invention should be novel. It should have an inventive step. It should be non-obvious. It should have industrial applicability, and it should not fall under the non-patentable subject matters, which are very well explained in our Indian Patents Act 1970. Next slide, please. So yeah, this is the same thing. Next. So what is novelty? Again, it may seem repetitive. Still, I want to emphasize that these three criteria are very important when you file a patent application. So what is novelty? It's nothing but new compared to the prior art. Anything which is new. What is a prior art? Prior art, suppose today is March 18th, right? Anything, if you file your application today, anything published before yesterday will be a prior art for your invention. So it can be anywhere in the world, and can be any document in the sense, it can be a simple brochure, it can be a simple website. You have blogs are there, right? So if you write your invention or you disclose something in the blogs, it will be a prior art for the particular invention. So it is like anywhere. And if you have, as you know, now we all have a tendency to put everything in social media, right? We just disclose it through some medium. When we are excited about our invention, sometimes we just disclose it unknowingly, but everything which is there known to the public act as a prior art. So first, just be very careful when you have an idea or you are working on something. Just keep it to yourself for some time before you apply for a patent. So it can be, as I told, anything, any document, anywhere in the world. So if you do some experiments and you get it a similar result, so that is not novel. You should get something very different which is not at all known to the public before you file the patent application. Next. And as the previous speaker has already very well explained the inventive step. Yes, this is one of the very important steps which we all as researchers or as academicians must overcome. And this is one of the main objections we get during the patent FER, when the examination happens for our patent application. So inventiveness, as the definition goes on, it's a feature of an invention that involves a technical advance compared to an existing knowledge, or having an economic significance, or both, or that makes an invention non-obvious to a person skilled in the art. So there is some key things to be noted, that is the feature of an invention. See, that there should be something which is extra, which is more or enhanced in your, should be a technical feature, there should be something more from which is already being reported, already existing in the world. And there should be an economic significance of both. And all these things should make a person who is working in the same field. As the previous speaker has told about the first step, the person with an ordinary skill in the art. For in Indian case, it is FISTA, which is person skilled in the art. There is a difference. Skilled in the art. So the person with ordinary skill, it is about the average knowledge, a person having average knowledge in the field. But in India, it is more stringent, as we consider person who is working in the field, who has a substantial, very good knowledge in the field, who can understand the invention. So it is addressed to those persons. So it is a hypothetical person who is having a very good skill in the art. Okay, already in the field which we are talking about. Next slide. Okay, and another important thing is the industrial applicability. So your invention should be industrially, commercially made. It should have a commercial value, and it should have a real world benefit. It should benefit the public. So there should be a direct. So patent office always says these things, whether there is industrial applicability, where it is novel, where there is inventive, and these three are very important. That's why I repeated these things, so that it would be very well be in your mind. And also the most important thing, according to Indian Patents Act 1970, there are several sections. There are some 15 subsections in section 3, which mentions which all subject matters are now comes under patentability, which cannot be patented in India. So just briefing about it. Scientific theories. See, E is equal to mc square, and laws of thermodynamics. Those things cannot be patented in India. And aesthetic creations, like creative work, right? If you have a painting, you have sculptures or something which is appealing to your eyes, it cannot be patented. And there is mathematical models. See, you derive some equation, you come up with a solution and all, and you think this is very novel, this is very new. But no, in Indian patent system, you can't patent that equation. There are some other ways of protecting it, IP, for example, the copyrights. You can go for copyrights. And also the computer programs per se. The algorithms cannot be patented, but it can be copyrighted. And of course, the plants and animal varieties, if you create them, you can't patent it. But there are other laws to protect. And then surgical, diagnostic, therapeutic methods. Method of treatment of human beings cannot be patented, but there is an exception. You can patent very well the surgical devices, the syringe, the stethoscopes. Those devices can be patented. Okay. And any invention which is against public order or morality, for example, gambling machine, you create a gambling machine. So those things cannot be patented. And again, method of cloning of human beings cannot be patented. So it is against the ethical, social, well-accepted social norms. And also, the previous speaker has already mentioned about section 3D, that is any new forms of known substances cannot be patented, whether it is an isoform, it's the isomers or the polymorphs, that cannot be patented unless and until you prove the therapeutic efficacy or you have a synergistic effect. Okay, and also there are admixtures as such cannot be patented, and methods of horticulture, so on and so forth. So there are some 15 grounds which are mentioned in the Indian Patents Act 1970, which clearly says these subjects, when your invention falls under this cannot be patented, and it will be very well objected at the time of examination. And also these are very closely scrutinized at the patent office. And also that any invention related to atomic energy, if you do, your invention is related to atomic energy, it cannot be patented. Okay, next slide.
And this one query.
Yes.
Like in computer programs cannot be patented as you have stated.
Yes,
so
yes.
how can a particular computer scientist, if they are coming up with a model, how can it get like patented or something related to that? Like some other type of patents they can do.
See,
like developing a new model.
Okay, ma'am. You have, see, if it is an algorithm, pure algorithm, and it is new, but so it cannot be patented according to Indian patent law as if it is just an algorithm. But if you integrate with a hardware device, right, or you integrate with its functionality, you integrate with a hardware device, you create a device out of it, it's a new product, right, then it could be patented. You should have this technical effect has to be proved. Technical effect. Yes.
In continuation with what Dr. Philomena has asked right now, university is also in the what you can say, the process of applying for, like we are seeking permission to apply for US patent as well. So you can, but I think in for US patents, the algorithms or which place or region where we can actually protect the algorithms. Can you just mention that for maybe further understanding so she can move on?
So not in India, as our laws doesn't permit protecting as such, but in foreign nations it's there. So ma'am, you want the methodology? Or?
No, it's not the methodology. What I just wanted to tell you is that Dr. Philomena, perhaps in India, as per our Indian laws, it is not patented. But there are other regions where this algorithm would be put more use to, okay, rather than, നമ്മുടെ Indian, even if it is not in high demand, the type of work that you could do would be in demand in another region. Say for example the US. So there you can actually protect the algorithm there if you wish to do so. Okay, but then the question is that even if we apply for a US patent also, we will have to first file it in India, and then only we can actually move to the US patent. So there are certain procedures.
Actually, there is not necessarily you have to file in India, but you need to inform the patent office that you have to do. Then you can file the application wherever. Yeah,
and
that
also,
is mandatory.
there are other types of patents like design patents and utility patents. So.
Yeah.
How can those patents differ from the original patents, or all those things are same?
Ma'am, in India, we don't have utility patents as such. And only in US, Japan, these countries follow this. And we have design registration. That is different from design patent. We don't have anything called as design patent. We only have design registration according to the Design Act 1999. Okay. So US and Japan or China, they have this utility patent, and the procedures are a bit different. There is no, only the inventive step is examined there. There is the strict scrutiny is not there for the utility patents. And in India we don't have, we only have this system for patents. There is no design patent, there is only registration we get for that.
So whether that utility patent is like valued like the same patent which we get here or something like that?
Yeah, it has the value, it has of course the value, but in India we don't have this patent concept. Okay, then we can move on. Yeah, keep it there. So let me just introduce you about types of patent application. So in India we can file two types of patent application. One is a provisional application and another one is a complete application. So first of all, what is the provisional application? Provisional applications are nothing but when you have an idea, you do some experiments at the lab, and now few more experiments or few more area is to be done. At that point of time you can file a provisional. And also if you want to disclose your idea or your idea or your experiments to some funding agencies for say for third party, then you first you go and file a provisional because you are making a disclosure there, and you acquire a priority date, so that it is in India you have to we have the rule of first to file. Okay, not the person who first to invent who gets the patent or the rights. It's only the person who first files. So date of filing is very important. So secure the date of filing because somebody else may also be working in the same invention. So he may and it should not be that if you disclose it somewhere, it should not act as a prior art for you, so that it will restrict you to file the patent later. So that should not happen. Then for that, just file a provisional application first, and you get a period of 12 months. 12 months to file the complete application. Complete application is nothing but when the invention, as the name indicates, invention is complete. You have all the experimental data. It's complete in every form. Every drawings, figures, everything is complete, you file it, and there is only 12 months, within 12 months you have to do. This time period is very crucial. Okay, so that is from provisional,
So the amendment can be made till this 12 months period, right?
Yes, very well, you can only at the time of provisional you give the title and see, when it is published only the abstract is published. Not or at that time. I mean, when you give the provisional, you just have to give some idea, the advantages, everything in the specification. I am saying this. It is a specific application in the sense. It is a specification. You give the whole disclosure in that. Okay, it's a written document. Okay, so in the complete only we give every data. So there is a time period, this 12 months should be strictly followed. Okay, next slide please. And there are other patent applications which you must understand. See, there are several numbers you see here. There is ordinary, convention, PCT national phase. So no need to confuse about that, just to give you an idea this kind of applications are there. So what we file in India is an ordinary application. It is a local application which we get protection only in India. So it is, as the name indicates, an ordinary application or local application, and it has specific numbers. And these numbers, why it is important, when you get an application number, and these numbers has got some significance because it helps you to understand what is the type of application you are filing. It is just to distinguish between whether it is filed only in India or it's an international application. See, for convention there is a number, right, 4 and 7 for PCT national phase. And there are other, so in ordinary itself you need to understand there is two types. See, there is a divisional patent and also patent of addition. So what do you mean by divisional patent? Divisional patent, when you file a patent application, there is an examination process happen. I will come to that later. Then the examiner may sometimes think your particular application has got 2 inventions. It has scope for 2 inventions. Then what they will ask? They will ask to split the application into 2. File it as a divisional, separate application as a divisional application. And what is about the patent of addition? Patent of addition is nothing but when you file an application and you get the patent granted, then after some time you think you need to modify, you find something very novel, you modify the original, or you come up with some modification or improvement in the already filed patent, then you can go for a patent of addition, which it will be like a child. The main patent will be your parent, and then just think in that way. So what is the use of patent of addition? Patent of addition, you know, after after getting a patent, you need to give the renewal fees. So in the case of patent of addition, you need to give only one renewal fee. Okay. But divisional patent, you need to give separate. It will act as a separate, separate application. So that is there. So about the convention and PCT, I will talk to you last. No need to confuse here. So these are the type of applications we have. Okay, next slide. Okay, just tell me. So now this one more here. So I will be talking about the patent prosecution system, which is the main topic. So how our patent application travels after drafting and filing our application, how it travels to the patent office. Next. So first, as I told you, you need to draft and file your patent application. Next. And next, there is a 18 months period. Every Friday they used to give this, they publish all the abstracts of this application, and only it happens after 18 months. This is a mandatory timeline. And so the patent details, the title, and only the abstract, and if there is a figure or flowchart, it will be published along with this. Not like the whole paper, if you see in your research articles, it's the whole paper publication. So it is different from that. So after 18 months, when your application is published, the abstract is published, what happens? You have a time period of 31 months. So 31 months, within 31 months, you need to file a request for examination. The request for examination is an important process in the patent prosecution, because unless and until you file this request for examination, you request the patent office to examine your application, they won't take up your application. Okay, and these 31 months are very important. Within this 31 months, you need to file that form. There is designated forms for all these. Next. And what happens when you file a request for examination? The patent office, the examiners will examine your application, and they will issue a examination report, which is known as the first examination report. The first examination report contains all the objections, if any, it will be scrutinized for, as I have told in my initials, like the inventiveness, the novelty, the industrial applicability, and whether your invention falls under any of the non-patentable subject matter. So according to the law, it will be scrutinized, and all the objections will be, whichever objections are there, it will be raised in the FDR report. Okay. And what next is, after the issuance of FDR report, you have a period of 6 months. Within 6 months, you need to reply to the objections raised by the controller. And there is an extension also, 3 months period extension. And then there happens the hearing. So the controller will call for a hearing with the patent agents. Of course, they will attend the hearing, and they will attend on your behalf. So, and you need to give a hearing submission. Finally, after hearing, all your all your suggestions, all your data, everything, whatever you say, you need to give in a hearing submission. So it's just similar to a court proceedings, if you say. Then filing the hearing submission, and after the submission, controller will decide, after looking into all the whatever things you have given, he will scrutinize, and he will just decide whether to grant your patent or to reject your patent. So this is what happens at the patent office, and it is a time. There is a strict timelines which I have mentioned, and there are several forms for that. So the initial forms are given here. During the drafting filing time, we need to file form 1, form 2, form 3, form 5, and form 18A is for 18 for request for examination. Yes, sir.
6 months extension ഉള്ളത് എന്താ EXP ഏതിനാ 6 3
Extension to 3 months.
3 months.
Yes.
അത് കാരണം
No,
6
okay.
മാസം പോലും 3 മാസം പീരിയഡ്
No, sir. It's like within 6 months you need to reply for the FER. Then again you can extend the time to 3 months by filing a particular form with the patent office if you need some more time to draft the reply. Okay. And these forms are very crucial when it comes to filing the patent application. And these are the filing fees. So form 1 is the initial form which you submit at the patent office, which has the applicant address, the title, and so for education institutes, for natural person, startups, MSMEs, they have 1,600 rupees they have to pay. And for the larger companies, larger entities, they need to pay a fees of 8,000. And other form 2 is the form which I was speaking about, the specification. You need to give a complete your disclosure in a format, right? That is the form 2, which doesn't have any fee. And also form 3 is there, form 5. You don't need to bother about these forms because patent agents will take care of all these formalities. And there is form 9 and form 18A, which is to expedite the whatever timeline I have just told. You can expedite the process by filing such a particular form with a particular fee. Okay, so this is for e-filing. 10% more is there for physical filing. Yes.
But it is like both column that startup is there. Previous statement. In that both column startups, they are charging 1,600, and second column is 8,000. Both
3,000.
startups are mentioned in both the columns. Natural person or startup. Yes, allow law with natural person or startup.
Yes.
Or small entity. Or institution.
Okay.
സ്റ്റാർട്ടപ്പ്
Okay, there is. You are saying on the act it is mentioned.
അവിടെ സ്റ്റാർട്ടപ്പ് ഉണ്ടല്ലോ അവിടെ വേണ്ട ഒരു സ്റ്റാർട്ടപ്പ് 8,000 വേണ്ട ഒരു സ്റ്റാർട്ടപ്പ് അതെന്താണത് അത് സ്റ്റാർട്ടപ്പ് വിത്ത് അതർ കമ്പനി സ്റ്റാർട്ടപ്പ് അലോൺ
Yeah. Yeah, startup alone is startup with other companies, big companies and other companies.
It is startup.
And
If it is startup with another company is 8,000. Startup alone is 1,600. Educational institute is alone is 1,600. നിങ്ങളുടെ എഡ്യൂക്കേഷണൽ ഇൻസ്റ്റിറ്റ്യൂട്ടും പിന്നെ കോൾഗേറ്റും കൂടെ ചേർന്ന് ചെയ്യുകയാണെങ്കിൽ ആരാണോ ഹയർ ഇത് അവരുടെ കൊടുക്കുന്നത് അപ്പൊ കോൾഗേറ്റിന്റെ ചാർജ്
yes,
മനസ്സിലായോ കോൾഗേറ്റ് കമ്പനിയുടെ ആണ് ഇത് സംശയമുണ്ടോ
what sir has told, that is
natural person.
നാച്ചുറൽ പേഴ്സൺ alone is 1,600. നാച്ചുറൽ പേഴ്സണും
with the company.
കമ്പനിയും കൂടെ ആണെങ്കിൽ
Collaboration then
നിങ്ങളെ ഒരു എംപ്ലോയി ആണ് ഓക്കെ ഹിന്ദുസ്ഥാൻ എയറോനോട്ടിക്സ് ലിമിറ്റഡ് എംപ്ലോയി ആണ് നിങ്ങളുടെ പേര് ആപ്ലിക്കൻ്റ് ആയിട്ട് വയ്ക്കണം നിങ്ങൾ നാച്ചുറൽ പേഴ്സൺ നിങ്ങൾ സ്വന്തമായിട്ട് അപ്ലൈ ചെയ്യണമെങ്കിൽ 1,600 രൂപ കൊടുത്താൽ മതി പക്ഷെ നിങ്ങളും നിങ്ങളുടെ കമ്പനിയും കൂടെ വയ്ക്കണമെങ്കിൽ കമ്പനിയുടെ ചാർജ് കൊടുക്കണം നിങ്ങളുടെ പേര് അവിടെ ഇരിക്കും മനസ്സിലായോ അതാണ് ഉദ്ദേശിക്കുന്നത്
I hope it's clear now. Okay, next. And the eligibility for expedited process. Yes, yes.
Suppose Turkey is actually doing, they have to pay the second one or?
Turkey will do first one.
First one, because it's an educational.
Turkey is an education institute. Turkey has 1/5 only they will pay 20%.
But 1 minute, Nimisha, but say for example, you have further developed your what you can say work and you moved to a prototype. This time you have decided to go ahead with an industry partner. Okay, and when you have the industry partner, that's what sir was talking to you about. Say for example, you have a Colgate. there the expense division would be 50-50 or whatever is the MOU that you have with the company. At that time the charges would shift. And university would be in a position to pay that charges. But still, faculty would need not actually worry about that part. That part we will take care.
Not only for filing, it is applicable for renewal.
For
as well.
renewal as well,
When it
yes.
comes to renewal, the amount will boost up again.
Amount will be very doubled, not doubled in 4 times.
One more thing.
Yeah.
When already existing startup is signing an MOU with all education institution, so for then onwards, this first column will be applicable. Right?
Yes. Startup. Startup and education institute, of course, 1,600 rupees.
അതിൽ ഏതെങ്കിലും കൊടുക്കാൻ പോകും സ്റ്റാർട്ടപ്പിന്റെ കൊടുക്കുക അല്ലെങ്കിൽ എഡ്യൂക്കേഷൻ
Yes.
ഏതെങ്കിലും
So if next
ഒന്ന് മതി ഇതിലൊന്ന് കൊടുത്താൽ മതി.
next slide, if for eligibility for expedited process, here if you prove as a startup, you need to give a certificate from DPIIT. It will issue that yours is a startup. So if you give that certificate, you can very well avail for expedited examination process and also expedited public. And if you prove as a small entity, which you get from Udayam registration or something from the ministry, then you can very well avail for expedited. And also natural person, or if joint applicants, all the natural persons, then at least one is a female. So female applicant, they can go for, they can avail this expedited process for examining their application. And also a department of government institution established by central, provincial or state act owned or controlled by government, and government company as per the Companies Act, some ONGC company, if they apply for invention, then of course they can go for expedited process. An institution wholly or substantially financed by government. And also India, if in the case of international application, there is a provision called as getting an international search report, and also international examination authority. If India is chosen as an examination authority, they can very well, that application can be very well go for this expedited process. Okay, next. So this is how an FER report looks like, just to give you an idea. This is the first page of FER report. After you draft, file, and after examination, this is a particular report which is being issued to you from the examiner. From the controller. Examiner examines it, and the controller issues this certificate. It has got the date, and also they mentions the time period within which you have to submit reply for this particular report. Okay, next. So what all things are there? What are important things which you get in the examination report? As I have mentioned earlier, the 3 main concepts, that is the novelty, inventive step, and industrial applicability. So which part is being examined thoroughly? It is the claims, which claims are the heart of the patent. It is whatever is claimed, only you get patent for that. It's like a fencing. Which is the strongest part of a patent. It is the claims. So claims are thoroughly examined for these criteria, and also for the section 3, which I have mentioned elaborately, from section 3A to P, that is about the non-patentable subject matter, which is mentioned in the Indian Patents Act 1970. If your invention falls in any of these category, that will be mentioned here. And also the claims will be very well examined for clarity, conciseness, and all. So it will be, in a summary, it will be given. This is the next page. It will be given like that, the report, and it will be mentioning the date of filing, which is very important. And also the examiner may come up with prior arts. They will do a thorough prior art search, whether there is your invention, whatever you have given is there, that is published already, is there in the somewhere published. So they have very good databases. Even if you do a thorough search before you apply for a patent, they may come up with some of the relevant documents which may be very closely related to your invention. So even if it's our duty to do a thorough search before you file or file for a patent, because patent office may somehow they have very good databases or very different professional databases which can come up with closest prior arts. So all those will be listed next. And also apart from that, formal requirements will also be mentioned in the FER report, such as if you fail to file some forms, form 3 or form 5 if you have not given, that will be also mentioned in the first examination report, and also whatever documents you have given, that will be also mentioned in the report. So that is about the FER report which you get from the controller. Next. So another thing that is very important when you consider about when you say about this patent prosecution is the opposition. Opposition may happen. Opposition can happen at two different stages when you apply for a patent. Okay. So that is there is a pre-grant opposition and a post-grant opposition. Pre-grant, as the name indicates, before the grant of your patent application, and post-grant, of course, after the grant. So, so when you get the pre-grant opposition, who can file? Any person can file a pre-grant opposition against your invention. Okay, and any time after the publication. So after publication, that after 18 months your invention get published, right? Then people who is they will be looking at your application. So people working in the same field, they will be very much enthusiastic to know whether what is there in your application, what is there. So they can see as I told, it is published in the patent journal in the Friday publication. They see, and they can anytime after publication they can oppose. And there are several grounds. There are some 11 different grounds given in the Indian Patent Act based on which you can oppose a patent application. So it is under section 25. One for pre-grant, pre-grant opposition, and post-grant, as I told, it's after the grant of your patent, before 1 year of date of publication of patent. So there happens two types of publication: publishing your application, the abstracts which is getting published at the earliest stage, and after the grant, the patent is published. So before 1 year is completed, anybody who is interested, who is aggrieved, can file a post-grant opposition, oppose your patent at the patent office. In order to explain it, I have just taken a simple case law on pre-grant opposition. You know, Novartis and Cipla, they are two pharmaceutical companies, pharmaceutical giants, we can say. All the medicines, very life-saving drugs have been from this Novartis and Cipla. So what happened? Novartis filed an application for patent for a drug called Difraceros, and this drug is prescribed to the patients of thalassemia or patients which has undergone multiple transfusion. So it decreases the iron load in the blood. So they have applied for a patent. So it's Chennai office, and Cipla filed a pre-grant opposition based upon I have told now section 25. They have several grounds which I am not going to explain. And controller allowed the representation. And you know, these for opposition there are particular forms. There are designated forms, that is form 7 and form 7A, which and it also has some fees. Earlier, what is that like in pre-grant opposition, any person can file. There was no fees. But according to the 2024 amendment in the rules, they have included fees also. Some 4,000 rupees for natural person and 20,000 rupees for companies. So now it is not free. It's like anybody can oppose, but they need to pay a fee. Okay, and what happened is the controller concluded that the claims were obvious, and it was already in view of cited art because the claims read upon previously disclosed ranges. So it was obvious, and also there is the controller, not the controller, the CIPLA has raised this. The composition is merely an additive property, except from expected from a mere admixture. So they have opposed, saying that it is a section 3E. It's a mere admixture of composition. And finally, what happened is CIPLA won the case because controller allowed this. Because they were able to prove these things. So Novartis couldn't file patent for this particular drug. So that is the thing of pre-grant opposition. See, mainly in pharmaceutical companies, see, they are more into creating the life-saving drugs. So there are several patient groups and there are several NGOs. They see, if we want to import a drug, so you know how costly it is. If it is very much charged, if it is very much, it is having a very high price, how difficult it is for the poor patients and all. So there are patient groups and there are NGOs, they will file oppositions when big pharmaceutical companies come and try to patent these life-saving drugs in India. So it is a kind, so it is something which is very helpful for the poor patients who cannot afford the drugs. Okay, so but this is another case because they were rivals. They are rivals companies, CIPLA and Novartis. So finally, CIPLA won the case because the patent they couldn't patent. Novartis couldn't patent this particular drug. Next slide, please. And another case law I have brought on post-grant opposition. It is the same. It is similar to Novartis versus Natco Pharma patent dispute, and there was a landmark judgment which was given in 9th January 2023. Novartis was the plaintiff. It holds the patent in India on this particular drug, that is Seratinib drug. And what happened is Natco Pharma, which is a generic company, it's a multinational company. So generic company, what they do, they will whatever patent, US patent, those drugs which are patented in US, they just take their formulation when it gets expired and they rework on it and produce the drug with the cost is drastically reduced so that the patients may get benefited. So what happened is Natco Pharma, they filed a post-grant opposition for this particular application. And what grounds they raised, that is they raised that there is a similarity, there is a prior art to this particular application. They cited a US patent which is from AstraZeneca. It is also a pharmaceutical pharmaceutical company, sorry. So what they did, Natco Pharma, they cited this prior art, and but somehow Novartis proved that this is different from what the Natco Pharma has claimed, and this is different from the patent, the AstraZeneca's patent, because there is some particular modification in some methyl group or something. But finally what happened, Novartis won the case, and the Natco Pharma has to give some compensations and all. So that is the case of post-grant opposition. Just for your understanding, I have brought these case laws. Next, please. As I have mentioned, there is two types of international application that also I want to explain here. How you can go about. There are two routes you can go for an international application if you file it in any other country other than India. So there is a Paris Convention route and also a Patent Cooperation Treaty. So these are agreements signed between the nations. So the nations who signed, they are called the member countries. And at present there are 176 members for Paris Convention, and for PCT there are 158 members, and India is a member for these two treaties. So what is that, when these treaties are signed, so it is that patent protection, the rights are protected in one nation. The similar protection they will, if an invention is, if an inventor is getting here, he will get the similar right in other nation also. That is the main thing. Next, please. So I will just give you a brief idea about what is this patent, Paris Convention route and PCT route. So Paris Convention, you file an application in India. Okay, you get a 12 months period. Within 12 months period, you need to file the international application. You need to decide which all countries you want to apply the similar patent. So only within a 12 months period, and each and every jurisdiction has its own laws and its own patent laws. So you need to file within 12 months if you go by a convention route. And if you go for a PCT route, you will get a 30 to 31 months period to decide to which all countries you can enter. So convention is the fastest process. If you need only 2 or 3 nations, only selected nations to file your application there, then you can go for convention. But PCT, what it gives you a longer period of time to decide. Okay, it gives only a single application has to be filed for entering into different nations. But in the other case, in the convention, you need to file a separate application. That is the difference. So you file a basic application in the 0th month. If you file today, and then after after 18 months there will be a publication. But in between that there is a office action happens. You get a international search report and a written opinion about your invention. Okay. So in India we have receiving office where you file. Either you can directly file at the WIPO. WIPO is the World Intellectual Property Organization where you file the international. It has international bureau where you file the international application. Okay. So after if you file a basic application here, you need to file an international application within 12 months. See, if you file a PCT also, that should be within 12 months. Okay, after 12 months you can't file for an international. If you are thinking, you have to think in that period. And you can later decide which all countries you want to enter. But filing, there is a timeline that is strict, and that is 12 months. Within 12 months you need to file the international application. So in the case of PCT, single application will do, and you can enter into different nations. You have to mark it which all nations you want to enter, and that will happen only after 30 months or 31 months. It depends on the jurisdiction or nation, what laws there it is followed. Okay, so that is there, and there is a written opinion as I told. So in conventional application you don't get a written opinion or a detailed search. Okay. But here you get those things, so it is more advisable to go for a PCT when you need some time. But you can very well go for convention as well if you need a faster process. Okay, next. So concluding my presentation. So yes.
Suppose we one actually immediately go to the market or patent, that is. Can you do it in the first one that you are suggesting?
So sorry,
the Paris Convention, suppose you want to make the patent very immediately, and then you can go for Paris Convention that you are actually suggesting, or
it's not immediately, but if you have decided which all nations I want to file my patent, okay, then see, if everything is this, you need to do a search also. You need to first of all make sure whether your invention which is already there or not in that nation. Okay. So if you want to, if you are very sure about the nation which you want to go, you can go for convention. But
suppose a product accident like immediately vaccine or something, you have to make it in the product very immediately. Then the Paris Convention is good for PCT.
It is not when this product is ready, and if you are very sure that in that particular nation it is not there, I can take it. I can go, then you can very well go for 1 or 2 nations if it is there. But if you want to enter all the 159 or 140, 158 countries at once, how will you make? There is you need to make a separate application for each nation, right? If you want to world over, whatever countries are there, you need patent in all those countries. 12 months, can you make it? So at that time, yes, sir.
പുള്ളിക്ക് ഒരു പേഷ്യൻ്റ് ഒരു കൺട്രി പോയാൽ ഓക്കെ അത് കൺവെൻഷൻ റൂട്ട് എടുക്കണോ പി സി ടി റൂട്ട് എടുക്കണോ ഏതാ എടുക്കാൻ ചിലവ് കുറവാണ് അതല്ലേ ചോദ്യം.
Yes, one country then you can go for that.
Then what is the difference between the financial?
Financial, sir, it depends. It depends to which country the prosecution fees and office fees all will be different for different nations. Okay? Yes. So key takeaways. So patent prosecution in India is a multi-stage process, as you know, as you have heard now. It has got several steps and timelines which has to be strictly followed. And understanding the nuances of patent law is crucial for a better enforcement and also getting a patent. And strategic planning is essential. So it is not that just to get a patent. As ma'am has told, you need to take it to the market, take it to the next level. So a strategic planning at the initial stage itself is very much essential to have in order to get the real benefit of the patent. Otherwise it is just a piece of paper, it's just a certificate. But you need to commercialize it, make revenue out of it. That revenue can be used again for further research. So that should be your aim, not just keep it just a piece of paper. It should be translated, it should be taken to the next level. And you should stay up to date with the changes. There are changes in the laws, so have some idea about what are the changes happening around you, okay? And there are legal experts, patent agents to help you, so you don't have to worry about the forms or fees, whatever. Just always have a consultant, always take an expert opinion while you go for a patent, okay? Because a small negligence in any of these steps may cost you. Your patent either may get abandoned or may get rejected. Or so you should be very careful, and always it is advisable to take an expert help. With that, I would like to conclude, and thank you so much for your patient listening.